Yeah, hello.
Honorable, good evening.
Good evening. If you can speak up a little bit, it will help me because I can hardly hear you.
It sounds like it's raining where you are.
Ah, no. Okay, all
Okay,
right.
but can you hear me?
Yes, I think it's better now. Yes.
Great. Okay, so you are saying that you're going to, or you have filed an appeal against the order by the High Court sitting in Koforidua, which has found your colleague in contempt and convicted him, awaiting sentencing, and also issued a bench warrant for him. I think the first question would be, prevention is better than cure. You could have prevented this if you did not let him go for the swearing-in ceremony in the first place. And then you wouldn't have gotten to where you have gotten to, where he had to disrespect a court of competent jurisdiction, which court now is going after him.
Well, I mean, I understand where you're coming from, but if you look at the situation on the night of the 6th January, clearly we were of the firm belief that no action could have been brought to legally restrain him from coming to Parliament and be sworn in. Because, look, the law is very clear on what you can do or when an action of this nature matures. If you look at the our Constitution and the Representation of People's Act, clearly an action challenging the election of a parliamentary candidate or a parliamentarian can only be done 21 days after the Gazette of the said result. And if you look at the Gazette of our brother, Mr. Kumi, it was done on the 6th of January. So there's no way anybody could have properly, in our view, brought an action to challenge his election. And that is why we allowed him, because legally we believe that the action that was brought, I think on 31st or so, hadn't matured to be brought in the first place. So that is how come we allowed him to be sworn in.
Sir, you're a lawyer, right?
Yes, sir.
And you do know that if a court gives an order and to that order is overturned by a higher court or by the same court, it's valid and must be respected, right?
Yes, of course. I mean,
Good.
when the court gives an order, it has.
So it's a yes,
It
right?
has.
I'm
saying that I don't have to be a lawyer to know that when an order is made.
No, I was asking that so that it will be a
order.
premise for me to ask my next question. So my next
So,
question was
and I think I've made that point that yes.
So my question was going to be then that regardless of what you believed was the process that ought to be adopted, the fact that the High Court, which is one of our superior courts, makes a decision, regardless of gazetting or anything else, you ought to have obeyed that injunction in the first place before you go challenging it, no?
I'm saying that if the court acts in error, because the court did not have the jurisdiction in the first place. The court did not have the jurisdiction in the first, because the matter had not matured to be brought before the court. You understand? And that you need to understand that yes, the fact that the court has made that decision has to be respected, but we also need to understand and challenge the court. Now, look, you cannot, as it were, assume jurisdiction over a matter which hasn't matured. Yeah, and that is where the difficulty was at the time the said decision was made. And we believe that the decision was impugned. The decision is that the court, by even assuming jurisdiction, we should challenge the court. Maybe you should ask the judicial service why these things happen. And of course, we took proper steps to challenge that. This judge decided that in spite of all the challenge, the fact that we believe he had wrongly assumed jurisdiction of a matter which hasn't been matured, we have sent this to the Supreme Court. The fact that he had displayed clear bias, and we have challenged that and have asked him to recuse himself. In spite of all this, this judge, who I believe was very partisan, this judge decided to go ahead and pronounce judgment and engage in this or give this decision which for me is in bad taste to, as it were, send our colleague to jail. It's a very sad situation. It's something that I believe should be tolerated.
So it's one thing challenging or disagreeing with the court's decision, but it's another thing disobeying the court's decision. So your colleague disobeyed the decision of the court. Whether or not the decision of the court is right in law or not, you do not disobey. You challenge through the processes that you are using now. Do you not think, and again, I'm going back to my prevention is better than cure theory, that if you had prevented your colleague from being sworn in, you would have not met the problem you're meeting now? Because I recall, and you're referring to ripeness, isn't it? The principle of ripeness, where there is no law that says we are anti-LGBT, or the anti-LGBTQ bill, for instance. It was not a law, but it was challenged in the Supreme Court, and eventually the court concluded. There were many people who said the law was not ripe, it's pointless going to challenge it, but it was still challenged, and until the court took a decision, we didn't know how to proceed. You could have waited for you could have prevented this by not allowing your colleague to be sworn in. That's the point I'm making to you. Do you think that with hindsight now on your side, you would say it was a mistake to have allowed him to be sworn in?
I will not say that. Of course, at the end of the day, I believe that we will successfully set this decision aside. And for me, that is very important. They shouldn't allow a situation where the courts will also act, when plainly the law prevents them from taking certain steps, and the judges go ahead to do it because it suits a particular agenda. I believe that, look, whilst you want to, as it were, look at whether by coming to Parliament to be sworn in was good or not, you should also be asking questions of the judge's decision. And look, we need to be fair in this country. If a matter is not ripe for hearing, it's not matured, no judge should be able to take a decision on it. And on the basis of that, in spite of all the appeals, to the extent that there's a certiorari before the Supreme Court to question your decision, you still believe that you want to go ahead and jail this person. Look, I think that, in my view, and it's sad to say, that the consideration for reaching this was not law, but something different, maybe political.
Okay, moving forward, while you are arresting that decision of the court, you are appealing, he ought to go and appear before the court. Now a bench warrant has been issued. He's supposed to appear and be sentenced. How are you going to navigate that particular one? Are you going to let him show up in court so that the court will decide what to do with him while you're litigating it in a different forum? Or you would continue with your litigation at the forum you are now and avoid the court and make sure the court doesn't get hold of him?
I mean, look, I am not his lawyer, even though I support his decision. I'm sure his lawyer will properly advise him. There's a lawyer on record who will advise him. I shall to offer legal advice on phone or on radio, but I'm sure his lawyer will advise him. Today he was in the chamber. I'm sure you all know. You saw him. He actually made a contribution. He's a member of Parliament of the Republic of Ghana, and we ought to give him the courtesies and respect due any member of Parliament. He's a duly sworn in member of Parliament, and I think that we ought to give him that respect. Look, at the end of the day, whether to appear before the court for sentencing or not, his lawyer, in my view, will advise him.
Very well. Thank you so much for speaking to us.
You're welcome.
That's Honorable John Darko. He's NPP Member of Parliament for Swami in the Ashanti region. This is Eyewitness News. And talking about